This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about the Supreme Court of the United States and how it has finally rendered an insurance decision where it found that an insurer has the right to oppose a plan in Chapter 11 bankruptcy that exposes it to potential insurance fraud, and why SCOTUS unanimously gave the insurer the right as a party in interest to a Chapter 11 bankruptcy to comment upon and oppose a plan of reorganization. Truck Insurance Exchange is the primary insurer for Kaiser Gypsum Co and Hanson Permanente Cement, the debtors, producers of products with asbestos who had filed for Chapter 11 bankruptcy after facing thousands of asbestos-related lawsuits. As part of the bankruptcy process, the debtors filed a proposed reorganization plan. That plan creates an Asbestos Personal Injury Trust under 11 U.S.C. Section 524G, a provision that allows Chapter 11 debtors with substantial asbestos-related liability to fund a trust and channel all present and future asbestos-related claims into that trust. Truck is contractually obligated to defend each covered asbestos personal injury claim and to indemnify the debtors for up to $500,000 per claim. For their part, the debtors must pay a $5,000 deductible per claim and assist and cooperate with Truck in defending the claims. The plan treats the insured and uninsured claimants differently, requiring insured claims to be filed in the tort system for the benefit of the insurance coverage, while uninsured claims are submitted directly to the trust for resolution. In Truck Insurance Exchange v. Kaiser Gypsum et al., a June 6, 2024 decision of the Supreme Court of the United States, the court concluded that an insurer with financial responsibility for bankruptcy claims is a party in interest under Section 11,009B that may raise and may appear and be heard on any issue in a Chapter 11 case. Truck sought to oppose the plan under Section 1109B of the Bankruptcy Code, which permits any party in interest to raise and be heard on any issue in a Chapter 11 bankruptcy. Among other things, Truck argued that the plan exposes it to millions of dollars of fraudulent claims because the plan does not require the same disclosures and authorizations for insured and uninsured claims. Truck also asserts that the plan impermissibly alters the rights of the insurer under its insurance policies. Justice Sotomayor issued the opinion for 8 members of the court, with Justice Alito not participating, and all 8 agreeing. Chapter 11 bankruptcy offers individuals and businesses in financial distress a fresh start to reorganize, discharge their debts, and maximize the property available to creditors. Chapter 11 is designed to strike a balance between a debtor's interest in reorganizing and restructuring its debts and the creditor's interest in maximizing the value of the bankruptcy estate. A party in interest enjoys certain rights in the proceedings, including the ability to file a Chapter 11 plan when a trustee has been appointed, request the appointment of or removal of a trustee, challenge the good faith of persons voting to approve a plan, and object to confirmation of a plan. Truck was the debtor's primary insurer. It issued policies that covered the debtors from 1965 to 1983. Truck is contractually obligated to defend each covered asbestos personal injury claim and typically indemnify the debtors for up to $500,000 per claim. The debtors have to pay the $5,000 deductible. The plan required the bankruptcy court to make a finding that the debtor's conduct in the bankruptcy proceeding neither violated this assistance and cooperation duty nor breached any implied covenant of good faith and fair dealing. The plan treated the insured and uninsured claims differently. Truck was the only party involved in the bankruptcy that did not support the plan. It advanced three main objections. One, the plan was not proposed in good faith because it reflected a collusive agreement between the debtors and claimant representatives and did not require the same disclosure and authorizations for insured and uninsured claims. Truck claimed that this disparate treatment would expose Truck to millions of dollars in fraudulent tort claims. Two, the plan finding impermissibly altered Truck's rights under its insurance policies by relieving the debtors of their assistance and cooperation obligations and by barring Truck from raising the debtors' bankruptcy conduct as a defense in future coverage disputes. And three, the trust did not comply with various provisions of Section 524G, including the requirement to deal equitably with claims and future demands as required by the statute. Following the bankruptcy court's recommendations, the district court confirmed the plan and the 4th District sustained. Justice Sotomayor, analyzing the issues, noted that party in this conduct is best understood as, quote, a person who constitutes or is one of those who compose one or the other of the two sides in an action or affair, one concerned in an affair, a participator as a party in interest. This is from Webster's New International Dictionary. The court held that the insurers, such as Truck, with financial responsibility for bankruptcy claims, are parties in interest. Bankruptcy reorganization proceedings can affect an insurer's interest in myriad ways. A reorganization plan can impair an insurer's contractual right to control, settlement, or defend claims. A plan can abrogate an insurer's right to contribution from other insurance carriers, or, as alleged here, a plan may be collusive in violation of the debtor's duty to cooperate and assist and impair the insurer's financial interests by inviting fraudulent claims. An insurer with financial responsibility for bankruptcy claims can be directly and adversely affected by the reorganization proceeding in these and many other ways, making it a party in interest to the proceedings. Truck will have to pay the vast majority of the trust's liability. The proposed plan would have Truck stand alone in carrying the financial burden because the injunction permanently and forever stays, restrains, and enjoys any action against the debtors. A plan that lacks the disclosure requirements for uninsured claims risks exposing Truck to millions of dollars in fraudulent tort claims. That potential financial harm attributable to Truck's status as an insurer with financial responsibility for bankruptcy claims gives Truck an interest in bankruptcy proceedings, and whatever reorganization plan is proposed eventually adopted, and the fact that Truck's financial exposure may be directly and adversely affected by a plan is sufficient to give Truck and any other insurers with financial responsibility for bankruptcy claims a right to voice its objections in reorganization proceedings. There may be difficult cases that require courts to evaluate whether truly peripheral parties have a sufficiently direct interest. This case is not one of them. Insurers such as Truck with financial responsibility for claims are not peripheral parties. Section 1109B provides parties in interest a voice in the bankruptcy proceedings. The judgment, therefore, of the United States Court of Appeal for the Fourth Circuit was reversed and remanded to the trial court. In my opinion, it's important to those of us involved in the fight against insurance fraud that SCOTUS Even Justice Sotomayor, writing for the full court, recognized that insurance fraud is a problem and that the insurer has the right to dispute a Chapter 11 bankruptcy plan that could expose it to many fraudulent claims without the ability to protect itself. The decision does not change the plan. It just gives Struck the right to oppose the plan and work to adjust the plan to protect its interests as well as the interest of the petitioners. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. Please tell your friends and colleagues about the blog and the videos and let them subscribe as well. You'll receive notice of every blog posting and access to more than 4,800 blog postings. If you're interested in more detail about insurance law, and insurance claims, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.